Okay, we are live. Greg Siskind here with Johnna Bailey, who runs Siskind Susser's litigation operations, and we're going to talk today about litigation. We're not about sort of like how to do it. We're actually just going to focus today, since this is kind of the Supreme Court's biggest week of the year, where they save the biggest cases. We're going to talk about Supreme Court, and we're going to talk about actually two cases that came from lower courts this week that were pretty important. So, Johnna, where do you want to start? I'll let you drive.
Wherever we can do the SCOTUS decision. I understand from my staff that many people are already emailing, so maybe everyone has questions on the Supreme Court decision and who it actually
This
impacts.
is Lao versus United States. So this was one that when I read it initially, I was like, oh, I mean, it's not great, but it's like, all right, but it's like we're talking about criminals who probably, how many people are traveling after they've been indicted and want to come back in on their green cards? There's probably not that many of them. And then we started hearing about, well, it's not really about that. So why don't you give a little background about what this case does specifically in this case, but also the implications it might have?
And I think it's the implications that will have the larger impact, because you're right, Greg, who this really directly impacts is a smaller subset than you would think. So the case background is for a lawful permanent resident who had pending criminal charges. So the question is whether when an individual with pending criminal charges, not a conviction, is returning as a lawful permanent resident, is this technicality between whether CBP has to admit them. So the term admission is a term of art within immigration. It's a right of lawful permanent residence. And it's basically evaluating whether CBP has to admit a lawful permanent resident who has pending criminal charges, or if they can parole. So again, parole, you're still coming into the United States. It's just a different mechanism. So the question here, like why does it make a difference, really has to do with, I consider it burden shifting, right? It's putting the authority into CBP to make a decision based on these pending charges. So it's almost like this miniature unauthorized trial at the border to see if the applicant, the lawful permanent resident, is going to admit to these different elements of this pending criminal charge. And it basically makes the process for losing that permanent residency easier if there is later a conviction. So again, you're hearing these facts, and it is like
it's not just like if you've been indicted that we're talking about. I mean, would be, I guess, a much narrower group, but it's basically anybody suspected of criminal activity.
And so I think this is where we're going to see CBP potentially kind of expanding even the language of the case. So I'm getting questions from, people who have never had interaction with law enforcement asking, is it safe to travel? Generally, yes. If you are a lawful permanent resident, you are fine to travel. I think what it does present is if you have any interaction with law enforcement and have pending criminal charges with upcoming international travel, that is an evaluation that you want to make with an immigration attorney. So very narrow who it should be applied to, very broad on who it can be applied to.
Yeah. So, I mean, basically, this is a first cut. I mean, it's been a while since the Supreme Court talked about rights of permanent residents. Generally speaking, from a constitutional perspective, we usually think of permanent residents as having almost all the same rights as a U.S. citizen. But this seems to be giving them a less due process than a U.S. citizen. Well, U.S. citizen, I guess, even if you're committing a crime, they still have to let you back in. But for permanent residents, this is, I guess this is potentially the, this administration never reads anything narrowly. They always read things as like, what does this mean as far as how we can go further on the next thing? And my guess is they're already thinking about ways that they can go after permanent residents in new ways that they haven't before. Like, and taking their permanent residency cards and holding, basically confiscating them, putting them into, some kind of limbo status. Do we know for people that are in this situation, what happens to their green card? Like when they're admitted in parole, is it, how do they get it back?
So it basically depends on what comes of the criminal charges. So what this is doing when you talk about due process, this is shortcutting due process, because if you've had an immigration attorney, and I, for the last 16 years, have said this to my own clients, you are a lawful permanent resident until an immigration judge says otherwise. This is fundamentally changing that. So for an individual who's paroled in, that is a mechanism CBP has had in their toolbox for a long time, and it's usually to resolve an issue. And if it's all resolved, they admit the lawful permanent resident. But if they're saying we're not admitting you until the resolution of the criminal charge, that conviction would effectively act as the revocation, and the individual can immediately be placed into removal proceedings rather than the lawful permanent resident being looked at for revocation proceedings. So it's a very technical difference, but in my lenses, it's shortcutting due process for permanent residents.
So let me ask something kind of in the same neighborhood that probably affects a lot more people that are listening, and that is people that are seeking entry that have been outside the United States for a long time. And historically, and I've had those come up since the beginning of my career, many moons ago. And basically, when somebody shows up that they think has abandoned their status in the US because they've been outside for so long, they usually will offer them either you can surrender your green card and we'll admit you as a visitor. I've seen that over the years. Or they give you, basically, they'll detain you potentially, but they'll quickly get you in front of an immigration judge, usually within a couple of days. And the judge would make the determination on whether you have abandoned your green card status or not. And I'm just wondering if that, if that's the kind of thing we might see next, where if CBP is already now making determinations in this subject, what's to stop them from basically saying, we're going to make the decision to terminate your green card, and we will let you in on a parole status or a visitor status, but we'll make that decision. You don't get to make that decision.
Yeah, and Greg, I can tell the difference between how long you and I have been practicing, because I agree with you except for the time frame. My experience is that doesn't take a couple of days, but sometimes a couple of years to get in front of it.
But they don't detain you the whole time.
Exactly. No, you're stopped for secondary inspection, and you're placed into what they call deferred inspection, which is a mechanism to parole you into the U.S. and come to like a meeting at a CBP office close to whatever your closest airport is. So Memphis has.
So I guess the question is whether that is going, whether that's in danger now of them simply saying, we don't have to wait for a judge to make that determination. We're allowed to do that.
Right. And that's what it sounds like, based on the fact that they're, emboldening these CBP officers at the airport to be, these side courts to make criminal charge determinations by clear and convincing evidence. Like, does a CBP officer know what that looks like in the criminal context? I feel like we're really struggling as a country to get trained and informed immigration officers. Are we now expecting them to be trained and informed on criminal law and criminal procedure? So it's really like putting a lot on those officers. And I'm not being sympathetic to the officers, please understand, but that's what we're looking at in terms of shortcutting due process.
All right, so that's not good, that case, and we'll just have to kind of wait and see how far it goes. So it's really, it's not the group that was covered in the case specifically here. That can't be that many people, but it's how they take this decision and potentially apply it in other ways, and that's what we're going to have to keep an eye on. All right, so we had two cases in two lower court. Well, we had a district court case and a circuit court case this week that had very different. They were probably greeted very differently by the White House. Let's talk about the one that they liked. the White House liked, not that we liked, but the White House liked.
Mhm.
The DC Circuit case involving expedited removal.
Mhm.
So talk about that case.
Yeah, so I'm going to even maybe back up and explain what in the world expedited removal
Good idea.
is. So we have different kinds of removal, and again, removal is just the legal term for what a lot of people refer to as deportation.
Yeah.
The difference in an expedited removal, it's the mechanism for actually CBP at airports or within 200 miles of the border who encounter individuals who were not, lawfully admitted into the U.S. to take them into custody and do this kind of shortcut. They're using the term expedited because it reflects just that. It's a very quick removal, either directly from the airport.
No day in court.
Exactly. So you're not appearing before a judge. So distinct from a standard order of removal, which is traditionally done in front of an immigration judge.
How long does it take right now if they do put you in front of a judge?
Oh, Greg, that's a silly question. So
I know, I kind of know the answer, but I want you to talk about this is because it will explain why they're so excited about this policy.
Right. So again, we're based in Memphis. I am no longer in court, but I think even my experience in court, I stopped taking removal cases in 2020. We are now in 2026, and I am still a solid 3 years out from wrapping up those cases that started in 2020.
Right.
In the
So
last
we're talking like 7, 8, 9, 10
years. And that's
Donald Trump will be hopefully a distant memory by the time people put in removal proceedings now actually have to deal with this issue. So if you can bypass the courts with expedited removal, that's a huge win for the administration.
Absolutely, because you're looking at saving time and you're also looking at saving those resources by not having to place anyone in detention, or even if they never detain the individual, them having the opportunity to have their case heard through the courts.
Yeah. So the courts, this is the DC Circuit, 2 Trump judges and a judge that wasn't appointed by Trump were I think it was actually, I don't know who the third judge was, but the 2 Trump judges voted against the other judge. And so I guess the options probably, and I looked for whether any comments from the plaintiffs, and they hadn't had comments yet when the news was reported last night. And I don't know if they've since, but they could ask for what's called an en banc hearing from the DC Circuit, where they ask all the judges to basically weigh in. And then, of course, they can appeal to the Supreme Court, but both of them are not. Well, the Supreme Court is probably not going to be what you want. The en banc is, they don't have to, but they might in this case, since it's a pretty major policy. So we have to wait and see.
I want to make sure we're really clear about the final holding. I don't know that I expressly said what this case was doing is expanding expedited removal nationwide, meaning it no longer is airport only or 200 miles within the border only.
So it means everybody has to be prepared, and which means, and let's talk a little bit about how we're going to advise clients. And the most important thing we have to advise clients is if you can document you have been in the United States 2 years, then you should not be expedited removed. Now, that's not to say there won't be abuses by the government where they ignore evidence, but you either need to, and also you should have documentation about your status if you are in fact in a status in the U.S. and you're not completely undocumented. U.S. citizens don't typically carry proof of their U.S. citizenship around, and we know there have been numerous instances of U.S. citizens that have been removed from the U.S. By the way, I carry this. This is a passport card. It's the size of a driver's license. If you have a U.S. passport, it doesn't cost that much money to get a passport card. It doesn't really do anything other than help you at land borders, like in Mexico or in Canada, but you can use it to come in and out of the country at a land border. So it is it's something that I would recommend that every U.S. citizen should get one and keep it in their wallet, just in case. You never know what kind of encounter you're going to have and when you might need to be able to prove your U.S. citizenship. But Johnna, like, what would you tell your clients about what kinds of documents to carry around or include in it? Because nobody has the ability to like carry like folders with all their stuff around everywhere
Right.
they happen to be at any given moment. But what would be the things that probably might be portable, the most portable things that they might be able to carry with them on their in their wallet or on their person that might you have to show basically that you've been here more than 2 years. But what kinds of things would you think would show that?
Yeah, again, so the individuals who would be vulnerable based on this decision are those who entered without inspection and have been here for less than 2 years. So when we're thinking about documenting physical presence of the last 2 years, those can be anything like a lease agreement, utility bills, bank accounts. And I'm very sensitive to the fact that people who are trying to live in the shadows based on their lack of status may not have those things. So you can look individually at your case and maybe try and get a document as early to when you first entered the US as possible. But like
Mhm.
Greg said, I understand that, a lease agreement may be 15 pages and you can't carry 100 pages with you at a time. So try and be like
Could have a school
consolidated.
ID card that has a date maybe
Exactly.
showing when and that's pretty portable. And that shows that you were enrolled in a school for younger people that might be watching this. Um, you can have, I guess, evidence of prescriptions that you got from those are usually pretty small that you've had over time with earlier dates than 2 years ago. I mean, you're going to need to get a little creative. Um,
Mhm.
but the burden is on you. It's not on the government. The government doesn't have to prove that you were here less than 2 years. They just have to show that you didn't have proof that you were here more than 2 years, and they had reason to believe that you were, that you were not documented, which is pretty broad. So that's all right. So that's not great. We have but we did have a kind of a good decision. At least, well, it is a good decision.
It is.
Let's take
Yeah.
good news where we can find it. So we had it helps. One of the most disturbing things that we saw early on in the administration were ICE officials who were hanging out at courthouses, ICE attorneys who were agreeing to dismiss cases, and then so that people would exit the courtroom, and then they would get arrested by ICE in the courthouses, and then escorted out of the country. Um, that has been ruled illegal by a district court. So, what do we know about that case?
Yeah, and again, I always like to take two steps back and talk about context. One of the first things the administration did was to remove the sensitive location requirement, meaning ICE did not used to be able to come into courthouses, into churches, into schools to detain
Hospitals.
hospitals as well. That was the fourth
Yeah.
one. Thank you, Greg. To detain individuals for immigration purposes. And this is, one step closer in restoring a safe place. So exactly, individuals who are in immigration court cannot be detained by ICE at the immigration court. So what Greg is referencing was a sneaky little trick that the government counsel was doing, especially for individuals here less than 2 years, which you heard me just say before the case started. They were trying to they were trying to expedite remove from the United States without a court case. So DHS counsel was coming and saying, "Oh, Your Honor, we're gonna agree to terminate this case," which sounds like a big giant favor until the case was terminated. They would immediately take the respondent or the foreign national into custody to expedite
I feel
removal.
like that's unethical. Like that there should be bar complaints filed against lawyers that did that.
It is a nasty trick, right?
Well, but it's also you have an ethical obligation to further the administration of justice, and would like to see them defend trickery, basically snowing, tricking the judge, tricking the lawyers for the other side, and basically having a scheme, which is all it is to do this. I don't think that's ethical.
No, most of my colleagues who are still in immigration court would oppose the termination. Most of the time they have applications for relief pending for the judges, and the judges would say, well, if the prosecuting arm does not want to proceed with the case, I cannot continue.
Yeah, I mean, I think the immigration lawyers started to catch on pretty quickly to what was going on, but
Yeah.
it's, so I don't know how active this has been lately.
Not recently, to my knowledge.
But these cases can take a while before a judge will issue a decision. So at least this is a tactic that will be hard for them to bring back. All right, Johnna, we have 3 cases that are sitting in the Supreme Court still that have to do with immigration. And so we are in the final days of the court. Usually they would issue all the decisions by the end of June. We don't think probably, but they sometimes will go into the first few days of July. There's some precedent for that, even though that some years they don't need to do that. But they probably will this year because they still have 11 cases left. And I guess Thursday is the last Thursday of the month.
Mm-hmm.
So we probably will see next Monday some of the cases. I don't imagine that they will do more than 3 or 4 a day. So I'm guessing it's going to go right up to the 4th of July, which I think is Saturday. So it would be the Thursday would be the 2nd of July. So we'll probably see a June 30th. And I think, the big one that we're going to talk about in a second is probably going to be on the 2nd of July, if I had to guess. So let's go in order of obscurity to most likely to make the country, an uproar on one side or another in the U.S. So the most obscure is probably the metering case on asylum policy. So this is why don't you explain what this case does?
Yeah, so I was curious about which one you would say is the most obscure. I agree. So this one is really looking at those who are approaching the border for the purpose and expressing the intent of applying for asylum. So it's evaluating whether those who express intent of applying for asylum, whether they can be allowed into the United States. And traditionally, always, this has been 100% legal. Like anyone has always been able to come to a border crossing, say, I fear persecution and would like to apply for asylum. Different administrations have treated this differently, meaning some have paroled. Again, I'm using that term. It is technically a lawful entry into the U.S. Others have been like, okay, you're in, time to apply. And this case is evaluating whether those who are expressing the intent to apply for asylum can be turned around at the border. So again, it's an evaluation from my perspective on due process. Is CBP making that decision at the border on, is this a qualified claim? Are we going to let you in? Do we think you will succeed on the merits? Not even looking at that. It's just effectively cutting off the potential implication.
I would point out that the U.S. I hope that they bring it up in the decision, and if they do, I think it might not be a terrible decision. But the U.S.'s international treaty obligations, which effectively say that this practice violates our treaty commitments. You don't see it come up that often in major cases out of the court, but treaties should mean something, and in this case, it's being ignored. I also just put on the screen, you can all see it, the New York Times did a nice rundown of the 11 cases that are pending and also what the public opinion is on each one of those cases that are left. And I'll show them to you as we get to them in the discussion. But in this case, a healthy majority of the public, 12-point to margin, are against the administration on this. Not that the Supreme Court cares, and frequently they make decisions that, the abortion one is probably where 80% of the public was against what the administration did and what the court did. So they oftentimes will completely ignore public opinion, but sometimes it matters. And I think sometimes if it's a case is like going to be a 5-4 case, that public opinion will sometimes matter. And there are some justices like Justice Roberts who I think care about the reputation of the court. So they don't always want to go with the administration. And we saw that with the tariffs case earlier this year, for example. So we will see. but that's a that remains right now to be seen about how they will how they're going to evaluate this issue. I predict that that's going to be one of the ones tomorrow.
Okay.
Okay. Number two, I would say the TPS case. What do you think?
So TPS, oh, just predictions on the case.
Well, first of all, my prediction is on the asylum case that it will be a 6-3 loss for the public, a
I think
6-3
that's
for the
correct.
administration. So I'm not super optimistic about that one, but I would like to be wrong. But that's my prediction for
I
predicting.
think that's probably an accurate prediction. Again, when this ruling is going to be very specific, it's a border issue, and I think what
Okay.
we've seen the
Well,
justice.
what do we think about the TPS case? Tell us about
I'm going to be optimistic here, Greg, and I know we talked about this before, so I'm going to say this is a potential win. So I think there's some. I have a reason for this.
No, I like it. I like hearing that we're going to win.
One, I really have to be with TPSers, but this is looking at the whole TPS program. So TPS is temporary protective status.
Mhm.
It's been utilized by nearly every president except for Trump, who wants to end all the TPS programs. But it can be used when there's like a political climate situation that threatens its citizenship. It can be used when there's a natural disaster. And like Greg said before we got on the call, it can be broadly announced, right? Like the disaster doesn't need to be justified to say, oh, this is big enough that it's impacting 80% of the population. But courts have been consistent in saying that before the president can terminate TPS from those designated countries, it has to demonstrate that it's actually safe for the citizens who have been residing here to return. And I know we've been really swift to terminate all TPS programs. And Greg, you may correct me on this, but I believe the countries you said this particular case is about is Haiti and Syria. Is that correct?
Yeah, those two.
So those especially really need ongoing protection. And so I want to be optimistic and think that the judges will agree with me that those countries in particular, and I'm with all TPSers from all countries, but those countries in particular need ongoing status to.
I think there might be some nervousness about exposing 300,000 plus Haitians to swift deportation. And that would be, I think the public is this is going to be another Minneapolis if they decide to go down that pathway. And I'm hoping that the Supreme Court realizes that this particular issue, that's going to be like Minneapolis is all over the country, if they start to try and pick up Haitians and send them back. I hope that the court makes the decision the way you do. And I actually think the law gives them a lot of leeway to do that.
I agree.
Essentially, the president gets tons of discretion to admit a country, to basically declare TPS for a country. And they're not taking any rights away when they do that. So they get a lot of leeway for that. Plus, there's an emergency that's happening. So the president has to be able to act really quickly when they do that. But they still have to do it with a reason. It has to qualify either for environmental or safety or a disaster reason. When they take it away, generally there has to be, even with 212F with travel bans, the administration has to have offer reasons for it. They have to go through some kind of report. So they issue a report for that. In these cases, they have just basically announced that they were removing it with no story. They just said, we can do it, and it's over. No process or anything like that. So my prediction is they will rule against the administration, but basically give them a pathway, the administration, that may not be all that difficult for them to essentially get to the same place. where they would have to offer some, show some evidence that they did their analysis, and then they'll show some BS report that was issued by some right-wing think tank or the State Department, but basically without providing much. I do think also that that could potentially be challenged, especially for countries where there are travel warnings for U.S. citizens.
Correct.
Where the State Department on the one hand is taking a position that it's unsafe.
Mhm.
Now, if it's unsafe for U.S. citizens because U.S. citizens specifically are being targeted for some reason or another, that happens from time to time. That's one thing.
Yeah.
But if there's a warning against travel there because the situation is unsafe, I think the administration is going to be hard pressed to just say why it's safe for this group and not safe for this group.
Agreed.
And then that would fall under the arbitrary and capricious APA issues as far as how they make policies that are inconsistent with other U.S. With other U.S. policies. So we will see. But
are we guessing votes? I'll say 5-4 in favor of TPS, but I do agree with Greg that we may re-see this issue litigated for the very reasons you said, if they articulate reasons and they're not good enough.
Yeah. All right. So that now we have the one that's going to be the last decision released, and that is birthright citizenship, which was one of the first cases heard in the Supreme Court. So we have a proclamation that people forget because it was enjoined so quickly by 4 different courts that said that, was it after some February date, and I forgot what it was, 2025, that anybody that was born to at least one parent who is who is not a permanent resident or citizen. I have to go back and look specifically, but it's that they would not be considered a citizen at birth. It's not just 2 undocumented parents. It could also be a non-immigrant parent. And that was designed to get at, quote unquote, birthright tourism for people who are coming in as visitors. So that's the policy. By the way, I had this tweet the last week or the week before. It was after the first U.S. World Cup match, and Mr. Balogun, our superstar, who broke the U.S. record for goals scored in a match, he appears to be somebody who would. It was all sort of theoretical because obviously he was not born after February 21st or whenever it was, 2025. But had the policy been in effect when he was born in New York, he would not have been a citizen, at least from the limited documentations on the internet. And it's not really like, who cares about this one case, which doesn't really count. But you would have thought that I had basically, was a heretic, and some right-wing publication decided to take my tweet and basically pillory me over it. But that thing had like almost 1 million views. It had, I don't know, like something like 4,000 retweets. I mean, people went bananas over that. And I was like, really? Because a lot of the stuff I post, it's like, I don't get that much engagement. But that one did. And I think it sort of like tells you kind of like what the public reaction will be, one way or the other. However this decision goes, people will get pretty emotional over it. I did want to show the New York Times they didn't do a poll. I thought they did a poll on the TPS, and I'm looking for it and I can't find it. But this is their poll that they did on birthright citizenship. And the public is much more strongly for broad birthright citizenship than and in this particular case, where only 37% think that the administration's proclamation doesn't violate the 14th Amendment, which is interesting. And I think the public is onto something here.
Right. It's a constitutional issue, not just an immigration issue.
Yeah. So this is what makes it harder for the Supreme Court, because I think, like on abortion, the right to privacy that was always the basis for abortion decisions and birth control decisions and things like that. That was always sort of an implied right. This ain't implied. This is
Right.
like the Constitution expressly says that that the right that it applies to anybody that is born in the United States or subject to the jurisdiction thereof. And that part of it is what the administration is trying to argue, that somehow they're not subject to the jurisdiction. But there was a very specific meaning that it had at the time and since, the jurisdiction, which is that diplomats, children, are not
Right.
subject to diplomats are not subject to the jurisdiction of the United States. That is why they're immune from all their traffic tickets, and they have all kinds of other rights as diplomats, because they're not subject to the jurisdiction of the United States. So that is the Supreme Court has to basically change the way that term is understood. But I also thought one of the best things I saw on this, and it got a little bit of coverage at the time, like 6 months ago or so, is I think it was Georgetown University, their law journal. Somebody went back to look at the members of Congress that would have potentially been that came in immediately after and voted for the 14th Amendment, that would have been not U.S. citizens if they and there were a bunch of them, and that sort of was a pretty good indicator that they didn't that when they were voting for this, that's not the way they viewed it, because they're not voting to themselves out of office, and
Exactly.
they would have essentially been voting themselves out of office the way the amendment. If you read the amendment the way that the administration reads the amendment.
Well, and even the administration can't, in good faith, say that they think that's how the Constitution was written, which is where I think everyone has to be on board that this has to be shot down. Like, we have to maintain.
Right. So we agreed beforehand, this is either going to be a 9-0 if you think that they are all going to do their jobs, or 7-2 if we think there's a couple of hacks in there that are going to basically side with the administration because they just are looking at this through a partisan lens instead of a constitutional lens.
Precisely.
So that is, I hesitate to say 9-0, and then of course, and then it could be very wrong about that, but this shouldn't be close.
No.
I don't see any of the Trump appointees actually voting with him on this. I don't think Kavanaugh will. I don't think I don't think the Gorsuch, and I don't think Barrett Brown will either. So we'll see on that, and we'll know starting tomorrow what we're looking at. We did have 2 questions that I'll take this out and I will put one question from one of our regular viewers who asked about when I think a decision on the emergency stay from the First Circuit will come. We were talking about this earlier in the Impact live stream, that has actually been the arguments on the stay have already been scheduled soon. I think it's like in a week and a half, and it will be apparently on YouTube, if I heard that correctly from Jesse Bless earlier today, or it might have been Zach. But that's going to be First Circuit is going to be tough for the administration to win. I don't think, based on the judges that I think are going to be hearing this, that it's going to be a very Trump-friendly hearing that they're going to get. So we will see. But on the other hand, it was an Obama judge was the one that sided with the government in the D.C. District Court case that initially went against. He's saying maybe it was the YouTube. Okay. In any case, thank you. And I told you, it was like I was trying to remember what I heard from Jesse. All right. So Dorcas is the 39 country band case that's going on YouTube. Uh,
Mhm.
okay. Sorry about that. Actually, it would be unusual for just a circuit court case to do it that way, but they do sometimes let you listen in on oral arguments. Um, the so I think we're talking probably in the next 2 weeks. They usually go fairly quickly on a stay. I don't know then if that's been scheduled or not. Thank you for that. The other case, by the way, we have a two other we have our case, Global Nurse Force in California. Um, 3 months now. We're waiting on a preliminary injunction decision. Chuck thinks that the judge is waiting on the DC Circuit Court of Appeals to make a decision on the chamber case, and that's what's holding it up, but nobody really knows. Um, in theory, he could be absorbing what was happening in the California v. Mullen case as well, but and then the DC Circuit Court of Appeals, we have no idea when that's coming either. They've already had their arguments like around the same time or before we had our arguments. So that's what I can tell you. Sorry about the that as far as the YouTube part of it goes, but I will be watching the Dorcas case on YouTube. The if that well, actually that one I think that judge really was that the one that was 135-page decision? I think it was. He really went into the weeds. Okay. Does it get updated? Yes. The answer is there will be an update. I just haven't looked at. It's not our case, so I haven't looked at it. But the on Pacer. But yes, Coral Listener. I'm not sure if they pick up all the scheduling, but I know Pacer does.
Is he still talking about the $100,000 fee case?
I think he's talking about the $100,000 one.
Okay.
But it doesn't matter. Dorcas would also be updated in the same places.
Greg, I'm sure you've talked about it, but I love preaching the kind of trick that you caught and the fact that the $100,000 fee has an expiration date, meaning
yeah,
if you're looking at
and I'm always afraid to say that on a public forum. But I will because
talk to us.
It's not that shocking on there. All you have to do is read the order, which says it expires on September 21st. So file a case that has a start date 10 days after that date, and that would be October 2nd or later. And the and then if you get if the government wants to fight you on it, the plain language of the proclamation says it only applies to cases that are have start dates before September 21st. So in theory, if you won the if you won the you're in the lottery and you have a deadline of when you have to file your case, file it and make that argument. I mean, better than not filing it. But if you have that win, you should. I would not wait for one of these decisions because they're not going to retroactively. I don't think they're retroactively going to go back and let people file.
Especially if you're a lottery case. Yeah, this is your chance to file before next week.
Yeah. We had a case that, somebody asked what triggered that green card decision we were talking about in the Lau case. That was the first thing we were talking about.
This case has been going on for a long time. So when the name you hear, Lau, is an individual who was in this situation and was effectively trying to fight his order of removal based on the procedure. So that's what triggered it. But unfortunately now it applies to everyone. So I can't remember the dates. I want to say he was trying to enter the U.S. It was before 2010. Like, it's been a long time that this case has been fighting. And poor Mr. Lau lost procedurally, and that impacts everybody.
All right. And this last comment is we're having this discussion about the $100,000 strategy. They probably will. But keep in mind what they said with respect to it when it came out initially. Remember when it came out initially and everybody was stuck outside the country and we were trying to find, and we were dealing with people that were in panic situations. And they said, oh, no, it's only going to apply to people that already that don't have anything pending already. So if you file something now for an October 2nd start date and it's pending, you're in the same situation as the people the first go around where they said that they didn't intend the order to apply for you. So they will have to change their tune as far as the way that they are implementing this order. Now they might, but that is that's what they're going to have to deal with. And also, it could cover people that are stuck outside the country again during that period who leave after September 21st. There are lots of people who think that the order, that the order doesn't initially apply to them until they make an exit from the country because they're changing status in the United States to H-1B status. But then when they leave and they need to come back in with a visa, that they, I believe, are covered in that situation, even if they weren't covered initially. Um, like if you're in an F1 now and you file for an H1B, I'm not talking about people before the proclamation took effect, but you're in F1 now, you file for an H1B, you get approved for H1B status, you leave the country because grandpa, is in the hospital or whatever the reason is. You're going to trigger the $100,000 fee to get the visa stamp to come back in, I believe. So, there are situations like that are going to be covered. Long and short of it is, I think that they might, if they extend it now, have to accept people like accept EXCEPT, people that already have applications pending for dates after the order was supposed to take effect. I don't have anything to base that on other than like they're attempting to be consistent with the first go around, but it is something I'd like to see, them, try it. Well, I don't want to see them try it. I'd like to see them just basically let this die. And there are some folks, maybe overly optimistic folks, who don't think they are planning on extending it, that they would like to basically let this thing run out without a loss. Where it's basically where it's still in limbo, the case, and that they can let it end on their terms. But we will see. And
$100,000 question.
yeah. And then this physician exemption. We have been promised a physician exemption from the H-1B proclamation since the very first week it was issued, and we never got it. I'm not counting on it, and that's and they created this national interest exception, which is what people thought they were going to use for it, and then they didn't grant any. So I wouldn't count on that. I also had questions today about physician exceptions to both the 39 country ban as well as the 39 country benefits pause. We have a lot of J1 doctors. I don't know what the number is, but it's like a third of all the residents in the country, or 25% of all the residents in the country come in on J1 visas. A sizable chunk of them come from places that are subject to these 39 country bans. And we don't have any exception yet to let these doctors come in for their residency programs. And that's going to be, my prediction is it's going to be hundreds of doctors, maybe even a couple thousand doctors that are potentially impacted by that. So, we have that group of doctors. And then we have a larger, we have this big group of doctors in the United States who are kind of in this limbo status where they're still not getting. I mean, I do know Chuck told me that we had 3 of our Georgia plaintiffs got EADs today, including a couple of doctors, I believe. So it seems like they are quietly accepting some doctors but those are doctors who are suing. And I'm not sure that we've seen it sort of more broadly apply for doctors getting accepted from it, except anecdotal cases we're hearing about where politicians are getting involved in a significant way. And so that's a good question. And whether you were talking about it with respect to the 39 country policies or the H-1B policies, in both cases, we have not. We saw the USCIS issue something seemingly accepting doctors in April, but we haven't actually seen that applied yet. We haven't seen anything public facing on their website showing that that policy is officially gone for them. So I wish I had better information, but really all we can do for the most part, because we don't get information from the government anymore, that through our bar association liaison committees, is we rely on what we see on listservs where immigration lawyers are reporting, as well as in social media where you guys are reporting on what's actually being approved. So something to keep an eye on, but thank you for raising that question. All right, Johnna, I think we have covered enough for tonight. And hopefully next week we will be back reporting on some good news from the courts, although I have a feeling we're still going to be waiting next Wednesday night for the Supreme Court's last decision. But you never know. They might decide they could wrap it up earlier. I don't know if there's anything that prevents them from releasing everything over these next.
Procrastination.
Well, if they're still writing it, but I have a feeling these decisions are already written, so we will see.
Sure.
All right. Well, that's it for tonight. Go USA. I just found out we're playing Bosnia, and we're supposed to be playing Bosnia next in the first round in the 32. So hopefully we'll see some good results, and we'll see you next time.
Till
Bye-bye.
next time.